Abusu ya mcheche obi biara emma obi biara kwa be de ba GH TV eso. Se mu nyina wo beka Oliver Barker-Vormawor ba bibiara owo no onda kuntunkunkuru jampantrudu ase na ona eye attorney general ene onimunyamfo John Dramani Mahama his excellency asepa esanse ene de atadufo wa esanse ablante kwa no ye charge ni treason po de ye charge wa ansha ubetimi ana ebetimi akunkura esanse wo ye omambofo obese obo oman no na den na abrante kwai oye ya ema ye charging sa chese kwotretwe nsem bi egu social media ne so na nsem no threaten eye onmunyamfo na na kufu ato obofo kese aga na nyina yedi na shaw se na bamu onu kura onya obetu agu esansa ombo ne homoden interface eye the country na abrante kwai oginam enam so ema chese ye de tabu emu edu te se Peter ni atopa to abrante kwai so se he who born dog Oliver untimi entu kwan ye gene passport ni bibia na ye charge no ye treason abusua enye afidi agro ene meka say atadufo wa abrante kwai chese ya redro na charges ni nyina na afina wadwene ye GH TV ma yenko the genesis of the issue.
Oliver Barker-Vormawor was arrested in February 2022 for making a post the state deemed treasonable on social media. On April 29 this year, lawyers representing Oliver Barker-Vormawor filed an application challenging the constitutionality of the offense and also prayed to the High Court for the case to be referred to the Supreme Court. In court today, Monday, the sitting judge was expected to pass a ruling on those outstanding issues to make way for a possible trial. It, however, turned out that the state only responded to the April 27 application by Mr. Barker-Vormawor's lawyers this morning. In an interview with Joy News at the court complex after the adjournment, Mr. Barker-Vormawor could not hide his frustration.
And you continue to see the charade and what has happened so far. Now, for them who paraded over 50 armed individuals and snipers, for them who believe that we were a threat to this republic, for so long they have not been able to match those words with the evidence that is required in this trial. Today, again, we've appeared before the court, where we filed an application challenging the constitutionality of the charges that were brought against me. Over 2 months, the Attorney General has chosen today, this morning, when they were supposed to commence trial, to come and file a response.
On social media, the activist has been vocal in his criticism of the state about the seeming delay in commencing the trial, a posture that some say could be inimical to his case. Mr. Barker-Vormawor, however, has a different view.
Activists to holding our institutions accountable, whether it be the courts or political actors who have for so long betrayed the rule of law. Now, I am certain that any judge that is sitting on that matter has a legal duty to consider only the evidence against them. But if the judge is biased or is coming from a place of prejudice or animus against criticism, then that in fact tells you the nature of the justice system. And so for me, it's a real test for them whether or not they can be able to contain just and democratic criticism, or that because of it, personal egos and think godism would transplant their duty to be able to observe the law and respect what justice demands of them. So
the judge is expected to pass a ruling on the constitutionality of the offense and the issue of jurisdiction when it reconvenes on May 27 to make way for the trial.
I'm interested in
I think that one of the biggest challenges we've continuously had in this line of cases, particularly that involve me, is that we are constantly seeing how a great deal of artificial reasoning and sophistry is applied anytime a matter involving me comes up. Not too long ago, the Supreme Court held that the Speaker of Parliament, who was under no constitutional obligation to refer a matter that comes before it to the Supreme Court, decided that when an issue arises before Parliament, which involves rival interpretations of the Supreme Court, before Parliament, the matter should be referred to the Supreme Court. In our case, we have challenged the constitutionality of the charges that are pending before me. A High Court refused, even though it's an constitutional obligation, to refer that issue to the Supreme Court. So we have come before the Supreme Court asking that that decision be quashed and they take up the matter, consistent with the way in which it has disposed itself in all cases involving the NDC. Well, today the Supreme Court has decided to reverse its own reasoning on these previous matters and decided that the High Court was right, that even though it has no jurisdiction to interpret the Constitution, to have interpreted the Constitution and refused to refer the matter. I think the only redeeming factor in this matter is that today Justice Kulendi has dissented, and that we are waiting to see what the dissent is. We saw in the same NDC matter that the dissent, at the end of the day, was more powerful than the decision of the majority, and that in normal times, when a court has been seized back of the normal operation of its reasoning, and I refuse to say impartiality, that maybe the correct way of the law would prevail once and for all. But I think the bigger question and the bigger threat to the rule of law in this country is the way in which the Supreme continues to flip-flop. Whether it is based on dislike of individuals, whether it is for partisan reasons, nobody knows at this point. So that today you can come in the Supreme Court in the morning and get a different reasoning if you are in the matter with different parties. And in the afternoon you can appear before the Supreme Court and be given a completely opposite reason. This is the challenge to the rule of law in this country. Now, well, the people of Ghana have spoken that they want a new dispensation in this country. Hopefully, as we have said, that even though the people of Ghana have given to the NDC the landslide victory, that landslide will be meaningless unless the judiciary is sanitized. Today we have seen an example of it again. And it's my prayer and hope that this judiciary is cleaned up, else this republic is not going anywhere.
Attorney General Dominic Ayin and I just say, John Dramani Mahama nam so ana obu aya chese wo se wo hwehwe nsem no kra enhyeda eni ayegina ye bia ntino e wa boni gada we Oliver mesra kọ menkoye boni biem kọ abusuan enye Oliver nko a eye odimunyamfo a ye frɛ no eye Dr. Stephen Opuni ene businessman Asiedu Agongo ena Dr. Johnson Asiama omu nyina na omu cases a na epende wo ho watimi aboa na ayisem no abonsem ni na gala we abusua enye afidi agro.
The Republic. Despite evidence to the contrary and knowing that they were subverting the laws of this country in order to achieve the political vendetta that the president had formed against myself and members of the country. It has been over 2 years since that incident. And in that interval, we have gone to the Supreme Court several times to compel the Republic to show up in court and prove the evidence that they claim they have against us. Every single day we come before this court, a court that is supposed to be committed to justice, a court that is supposed to give to each individual in this republic a fair trial. Consistently we've been met with nothing but tricks and adjournments. Now, for so many of you, we have continued to emphasize the point that we have before a regime that is not committed to the rule of law and to ensuring that every citizen lives to the promise of this democracy.